India's elected representative to the United Nations Commission on the Limited Continental Shelf from 2007 to 2014. He currently research interests include the internet linkage between the Indian monsoon and polar research region, different time scales, law of the sea, and non-living resource of the deep ocean floor. So from now on, Mr. Yares, Mr. Rajan is going to have his short, brief language of the, as you see, in the management of ocean resource continental shelf. The CLS batch was 2003, 2028. The many challenge of the road ahead. Dr. Rajan, former director of Nagpur, Goa, India, member of elect CLCS 2023-2028. Dr. Rajan, you have a floor.
Thank you very much. Yep. I hope you can see me and you can also hear me. Okay. A very good morning to you all. Thank you for the nice words, Professor Kim. And at the outset, I would like to express my deep gratitude to the organizers of this conference for the kind invitation extended to me, and especially to Dr. Young Kil Park, who, when I expressed my inability to be present in person, immediately made all arrangements to transport me through virtual space to Seoul. So thank you very much. I would also like to take this opportunity to acknowledge the services rendered by Professor Park, my colleague and friend for several years now, who will be stepping down from the commission after a long uninterrupted stint right from 1997 when the commission was established till 2023 June. So what Professor Park doesn't know about working of the community is not worth knowing. He is an institution by itself, and I would like to appreciate the services he has rendered to the working of the commission and who has resolved several of the problems which the commission was facing for several years. Thank you very much, Professor Park. And now, my presentation is kind of, okay. I hope you can see my presentation. Yeah, here we go. It's kind of a futuristic look at the working of the commission for the batch of 2023. The new members will step in by June of 2023 and the service will continue up to 2028. What are the challenges which the commission is facing as a unit? And what is the road ahead, especially focused on the working of the commission between 2023 and 28? And the way I've structured my presentation is that I will start off with the question of why do we need a commission in the first place? And why was it established? What are the objectives of the commission? And what makes this CLCS a specialist body, a different scientific and technical body, different from the other organs of the United Nations? And what is it that the commission members have been doing ever since the commission was established in 1997? What are the kind of challenges the commission has been facing, the kind of bottlenecks the commission has been facing, and what is the challenge that the commission is throwing ahead to the coastal states at large and to the CLC batch of 2023-28? So I hope. As before, the views expressed in this presentation are solely mine and they do not reflect in any way the views of the Commission on the limits of the continental, nor of any of the members of the CLCS elected for the next 5-year term of office commencing on the 15th of June 2023. So that's totally my personal views. I'm sure that at least some of you would be in tune with my viewpoint. So why was it established? What is the purpose of establishment of the Commission on the Limits of the Continental? Annex 2, Article 1 of the law stipulates that in accordance with the provisions of Article 76, a Commission on the Limits of the Continental shall be established. So primarily, what was the reason why it was established? To consider the data and other materials submitted by the coastal states concerning the delineation of the outer limits of the continental in those areas where those limits extend beyond 200 nautical miles, and to make recommendations in accordance with Article 76 and the Statement of Understanding adopted on 29th of August 1980 by the Third United Nations Conference of the Law of the Sea. Also, another function which has been entrusted to the Commission has been to provide scientific and technical advice if requested by a coastal state concerned in the preparation of the data. So as you can see here, primarily the function of the Commission is to examine the scientific and technical data which is submitted by a coastal state in support of its claims in accordance with Article 76. So that makes it a kind of a scientific body. So accordingly, as you can see, the Commission comprises of members who are experts in the three fields: geology, geophysics, or hydrography, the three disciplines of science, which are needed to examine the scientific and technical data submitted by coastal states. And they have to be elected by states parties to the convention from among their nations, etc., which is provided again in the Article 2, Annex 2 of the Law of the Sea. It also says that the Commission may cooperate to the extent considered necessary, useful with IOC of UNESCO, IHO, and other competent international organizations with which to exchange scientific and technical information, which also is provided in Annex to Article 3, Para 2. And it goes the credit to the Commission that so far the Commission never had any necessity to interact with IOC, UNESCO, or IHO on an official platform to seek their help or assistance or guidance. Okay. Having said that, as all of you might be aware, that CLCS was established in June of 1997, and in the May of 1999, the scientific and technical guidelines of the CLCS are adopted by the Commission. Immediately afterwards, on the 20th of December 2001, Russia became the first coastal state to make a submission to this CLCS in pursuance of Article 76. And as on date, there have been 93 submissions by 74 coastal states under the provisions of either Article 76 and or the Statement of Understanding. Which is a fairly big number. I'll come to, when I discuss the challenges, I'll come to the reasons for the submissions and the recommendations. And the submissions also include 9 revised submissions. So by revised submission, I mean a submission which has already been made to the CLCS and it's resubmitted after making the revisions suggested and recommended upon by the Commission. And there have also been 9 joint submissions involving 27 states. And interestingly, 21 coastal states have made more than one submission, with France leading the way with about 8 submissions, followed by Denmark with 5, Brazil with 4, UK with 4, Indonesia with 4, and so on, the list goes. But there have been several coastal states which have made more than one submission. And as opposed to that, there have been 47 coastal states who have expressed an inability to provide the scientific and technical information that's required by the CLCS before the deadline. Primarily, it stems from the developing nations, developing economies who don't have the kind of financial resources or the technical expertise to provide the requisite data to the Commission. So, in pursuance of a decision which was made at the 18th meeting of the States Party, it was decided that those coastal states who have to meet the deadline, the 10-year deadline, but who are not in a position to provide details to the commission, stating their claim. They can provide preliminary information, indicate the outer limits of the extent of condition and their probable intended date of making submission before the deadline. So 47 processes already made, provided the requisite preliminary information, and some of this preliminary information have since been made into formal submissions.
Be sure that the
So this graph here shows, can you see this? Yeah.
Dr. Razan, you should speak up very rapidly, okay? 15 minutes, okay? Good.
Okay, yeah, I'm going ahead right now. This is the kind of progress of submission which have been made. What you see in blue are the submissions have been made, 93 submissions as on date. And then what you see in the orange color or brown color refers to the number of recommendations that have been made. The peak you see here is the peak when you received about 35 submissions in May 2009 during the 10-year deadline. And now coming to the progress in submission, it's almost the same graph.
Minutes left.
Perspective. Hello.
5 minutes left.
Yeah, sure, right. This is the kind of thing, the new commission task. Actually, what you see here is that we have been able to make only 35 recommendations on date, leaving a large gap between the submissions and the recommendations. So what are the main challenging areas and other things? From one submission 2001, the number of submissions waiting for the recommendations has risen to 51. So there's a huge gap between the submissions that were received and the recommendations that were made. So taking note of the fact that the workload of the commission is increasing, the states parties are requested that can you consider the flexible size of submissions? Can you have an extended meeting of the submissions and we can have more frequent meetings of the subcommission? So, and then in 2011, it was also decided that the subcommission, the commissioners of the subcommission could consider meeting simultaneously as much as possible up to 26 weeks, but not less than the minimum of 21 weeks. So they have prescribed now that the commission has to meet at least not less than 21 weeks per year. So this has been a major challenge for many of the commission members because the main reason is that the increasing workload. I'm just rushing through the slides, unfortunately, because of the limited time available for me.
네, 시간이 매우 제한적인 관계로 서둘러야 하는 문제가 있습니다.
Yeah. Can I continue? Okay. The main reason, the challenges before the commission has been the requisite financial support for the CLCS members and appropriate resources for the CLCS secretariat, and there's a potential change in the composition of CLCS due to the extended time in New York and lack of quorum during the subcommission meetings. So the challenges are that available. See, another technical problem which the commission has been facing is the long gap between submissions by state and its consideration. So in between the time the commission receives a submission and when it considers new and technical and scientific data is made available to the commission, so which has a drastic implication on the submission. And the backward non-compatibility of some software used in the submission, and the challenges faced by some states, especially developing states, in preparing their submissions to the commission and retaining the technical teams for almost close to a decade and a half. So this is CLCS Act of 2023, which will come into place June of 2022. 7 members are new and 11 have been re-elected from the last commission. And there are 2 returning former members. By returning former members, mean people who have taken a kind of a break and they're back into the commission, like Harald Brekke from Norway and myself from India. And the composition discipline base, it shows that there are 15 geologists or geophysicists and 5 hydrographers. So the current status of conservation submission, as on December 2022, there are 11 submissions which are under different stages of consideration of recommendation by the current commission. If none of these submissions are recommended upon by the current commission before the end of renewal, these 11 submissions will constitute the first set of submissions for consideration by the new commission. So, considering the composition of the subcommission for these submissions vis-a-vis the 2023 membership, if you compare that, you will see that this new subcommission to be constituted for consideration of the 7 submissions will call for some required changes in the subcommission membership. And the number of changes would range from 1 new member per allow to all 7 new members will have to step in as subcommission members. Such changes in the composition of membership is likely or certainly likely to have an effect on the formulation of the recommendation, consequent probabilities. So these are the recommendations. I'll just quickly go through it if I get another 2 more minutes. See, right now what we do is this is again the recommendations have been adopted from 2002 onwards up to 2023. We have got a total of 9 submissions have been completed. So, I mean, total of 35 submissions have been recommended upon. And if you go in the same pace, by the end of 2027-28, we will be ending up with something only about 45 submissions of 90 will be completed. If you go in the order of about 2 to 3 submission approvals per year, but if you want to double the number of recommendations of the present tally to the end of 2027, that is, if you want to increase the total number of recommendations considered and submitted to 70, let us say, we have to have about 7 submissions per year will have to be considered qualified. It's a huge number because of the complexities involved, because we have to raise the yardstick from 2 to 3 submission recommendations per year to 7. So the challenges and the way forward, one way could be we can have more than 6 or more, or even 8 at a time if it's possible. Each of the 21 members be in more than 1 subcommission, which they are currently now. But how can we increase the number of subcommissions at a time? By adopting a more flexible approach, ensuring equitable distribution of workload, and encouraging the nominating state. This is something which I feel strongly about, encouraging the nominating state to ensure full attendance by the members so that adequate technical expertise is available. So we don't run out of quorum, So the nominating states have a responsibility to encourage the members to ensure that they attend all the meetings of the commissioners of the subcommission. And adoption of flexible approaches to which submission from the two should be considered next. So depending upon the available members, we will have to juggle around the composition of the subcommission. And again, another thing which might help us is that requesting submitting states for timely submission to the extent possible of additional data and or clarification as well needed the subcommission. See, this is one of the things which suppose let us say the subcommission is asking the member states or the postal states to provide them clarifications or additional data. If they are not in a position to submit additional data as requested by the subcommission or the commission, there's going to be a time lag between the submission consideration and the recommendation. Exploring the feasibility of considering the amended or revised submission. Is it possible that we can consider amended or revised submissions at the commission level itself rather than going through another subcommission itself, which can, I feel, we might be able to cut down the timing. Extending to the extent possible the requisite support of the CLCS members in the context of implementation clause 229. That is extending requisite support not only to the CLCS members facilitating some stay for about 28 weeks a year uninterrupted, as well as to the secretariat. The secretariat has got a major workload in the process that if increasing the number of days of stay of the CLCS member, this kind of secretarial assistance which is required. The GAS leaders who are required from the DUALAs, we have also to extend the support to them. So I'll stop with that and thank you very much for giving me this opportunity. Thank you very much. Thanks.
Thank you. Thank you very much. And you're looking forward to your asking the questions about our audience. Okay, good. Have a good time.
You.
And the next speaker is David M. Ong, Professor of Nottingham Trent University. David Mr. Ong, a Professor of International Environmental Law at Nottingham Trent University, UK. where his main research interests are the international following three fields, namely the international law of the sea, international environmental law, and international investment and development finance law. And a major aspect of the research has focused on the interactions of the special applicable international and national legal regime at marine environment, space, as advanced by major contributions, the edited volumes published the pre-eminent UK and international research institute in these fields. And his major topic today is continental shelf resources, problematic continuing unresolved issues and inadequate legal prescriptions. David Ong, Professor, Nottingham Trent University, you have the floor from now on. Okay, thank you.
Everybody hear me now? Yes? Is the mic on now? Yes, thank you. Well, first of all, of course, as with the other speakers, I'd like to thank Dr. Park from Korea Maritime Institute and the Korea Maritime Institute in general for inviting me back for the first, certainly for me, the first conference. Yes. Thank you. I'll speak a bit louder. Actually, usually my students don't have a problem hearing me. In fact, they don't really want to hear me most of the time. I was just saying how grateful I am to be here back in Korea in the post-COVID, well, hopefully the post-COVID era. It's been, a real joy for me to come back to Korea, and in particular, to be able to enjoy my great liking of Korean cuisine again here in Korea. So, without further ado, because I think time is marching on, and I have, as usual, far too many slides, let me get to the issue that I've set myself. Dr. Park was very kind to say to me, basically to give me a little bit of a carte blanche. He said, follow the theme of the conference. And the theme of the conference, of course, is not only commemorating the 40th anniversary, but also, of course, especially looking at unsettled issues. And it's already been mentioned, Dustin mentioned, Professor Wang mentioned yesterday that, it's very important for us to, of course, commemorate the fact, the successes of UNCLOS, but also re-examine some of its continuing issues. So I've set myself the issue, it's a big area, of course, relating to, and this suggests that I'm well versed in French, which I'm not, the continental shelf resources problematique. What are the continuing resolved issues and inadequate, and in my view, some inadequate legal prescriptions? And this follows on, especially from Professor Nishimoto's presentation, Kentaro's excellent presentation yesterday, along with all the other excellent presentations. And in fact, that allows me to kind of skip through the first of my presentation topics, which is the continuing problems with shared non-living resources in the continental shelf, and then move on to continuing legal issues with living resources in the continental shelf. Now this, I believe, might be a little bit of a surprise for some members of this audience, but of course we are dealing here in particular with issues surrounding the sedentary species aspect and the relationship between those species and the newly coined term, relatively newly coined term or phrase of marine genetic resources, which I'm sure everyone here knows is the subject of the newly proposed and Kentaro tells me that we're very hopeful that the new agreement on the BBNJ, the Biodiversity Beyond National Jurisdiction Agreement, whose negotiations go into a hopefully final negotiating phase early next year, will hopefully yield an agreement that can be adopted. And then we'll look very quickly also at legal issues in the relationship between UNCLOS and this prospective BBNJ agreement. And finally, we will have a look at the applicable principles for negotiated dispute settlement as well. So, and the point to make, if I can just go back to that, actually that's probably the most important aspect of what I'm going to be saying today, and that is that while we do have some of these applicable principles, and some of them have already been raised in the various presentations before us yesterday, principles like due regard and restraint or refraining from undue interference, in my view, these are still insufficiently well interpreted and applied by the relevant tribunals to come up with standards of behavior. So we need to move really from principles to rules to standards of behavior between states. And that is where we find, I think, the success of the convention with resolving disputes arising from this continental shelf resources problematique. But of course, not just problems relating to continental shelf, but also across the Law of the Sea Convention. Sorry, yes. And so, very quickly in relation to the first topic, you can see that in the kind of latest of the cases relating to non-living resources, or where there's been a suggestion of non-living resources which are shared, arguably, and therefore have to be somehow accommodated between two states on the continental shelf, on a common continental shelf, claimed by both states. In the Somalia-Kenya case, we see that the court noted Somalia's claim, but then rejected it on the basis, Somalia's claim of alleged authorization of drilling activities, which Somalia held would therefore amount to a breach of the relevant articles of 74 and 83. And the court initially sort of holds that such activities may alter the status quo between the parties. And here's a very important aspect of this sort of balance between how far states can undertake unilateral action in an area of undelimited continental shelf, which is possibly also subject to overlapping claims. The court, in this case, concluded that on the basis of evidence before it, the court was not in a position to determine it with sufficient certainty. And very quickly to say that that the court here, and for these reasons, the court found that Kenya had not violated its international obligations. Now, my view here would be that the court seems to be relying on a combination of a high threshold of evidence provision on the part of the claimant state, so the state that considers that its interests have been negatively affected by the actions of the other state, and it combines it with looking for or searching for evidence of sufficient due diligence on the part of the respondent responding state, in this case Kenya, which had undertaken some authorization. So this shows that actually that balance is still in the weighing, as it were. We are still a little bit uncertain as to what types of unilateral action that can be allowed in an area of undelimited maritime, undelimited and therefore disputed maritime area or overlapping claims. But moving swiftly on, I want to then also now pick up the issue in relation to the relationship between UNCLOS and the BBNJ agreement. Because here we see that through especially the further revised draft text, and this provision has been in place in previous drafts as well, nothing in this agreement shall prejudice the rights, jurisdiction, and duties of states under the convention, meaning here UNCLOS. And this agreement shall be interpreted and applied in the context and in a manner consistent with the convention. So my view here would be that this provision appears to privilege UNCLOS over the BBNJ agreement. But if so, this is, in my view, an anachronistic approach to the notion of the BBNJ agreement as an implementing instrument for UNCLOS. Normally, we would expect the lex specialis to lead the lex generalis. But here, the lex specialis, in the form of the BBNJ agreement, is reverting to, for the purposes of interpretation, to UNCLOS, as we can see here. And so that, in my view, especially considering that this is a conference in relation to the 40th anniversary of UNCLOS, actually arguably sets us back in terms of progressive notions, in particular of conservation and sustainable use of these resources, which have come about really in the last 40 to 50 years. So, again, moving on swiftly, this is just to show the area which will now come under the remit of the BBNJ agreement. Although this particular map shows very crudely the 200 nautical mile limits, but we can see here that even with continental shelf going beyond 200 nautical miles in many places, as Dr. Rajan very helpfully introduced to us in his previous presentation, we can see here that large parts, well, an incredible amount of the proportion of the oceans around the world will fall under, arguably under the jurisdictional competence of the BBNJ agreement. And the next few slides we can skip over. They were really just to show us, or rather show the audience what, show all of us the area that I want to focus on. And that is the far right area, as all of you look on the screen, to the screen, the far right area. Because we see that then that area of continental shelf where states have made claims beyond 200 miles, obviously extends into the high seas and abuts or adjoins the deep sea bed area, which of course, as everyone knows, is the remit of the International Seabed Authority to be sort of managed according to Part 11 of the UNCLOS, as well as, of course, the implementation agreement of 1994. And here another slide to very quickly just establish that we are talking about quite a, in many areas where states have made claims beyond 200 miles for their continental shelf, obviously quite an extended area under the high seas. So it's, yes, it's important to understand that this is a unique, in my view, a unique conjunction of maritime jurisdiction zones. Coastal state sovereign rights over the continental shelf as against superadjacent high seas. For example, an offshore drilling installation on the continental shelf beyond 200 miles would be licensed by the coastal state and indeed regulated in terms of all activities on board, as it were, the drilling installation, but then located within the high seas and therefore having to obviously make arrangements in relation to possible impingements on navigation and other activities generally accepted as traditional freedoms of the high seas. So does the preeminence of coastal state interests in the continental shelf regime carry on into the continental shelf beyond 200 miles in the face of other states' interests in high seas freedoms, right? And here we can see the reason why I focus especially on the continental shelf is it does hold a particular space, a particular place within the, if you like, the hearts and minds of states. States really do consider this extension of sovereign rights into their territory in the seabed as very much part of their territory. And in my extended abstract, which hopefully everyone's had a chance to look at, I suggest that this is a kind of, this is a form of regulatory expropriation. Of course, we have Fred Soanes here and his wonderful, dearly departed colleague, Professor Barbara Kwiatkowska, used the term creeping jurisdiction very famously in an article and in her book. So we see here that there are examples throughout the convention of the, if you like, the privileged status of the continental shelf. We see here that even when we talk about cooperation of states in semi-enclosed seas, we talk about management, conservation, exploration, and exploitation of the living resources of the sea, but not including non-living resources, which are, of course, actually falling within the original conception of the continental shelf. So, and here again we see again, in another provision under Article 142, where, and this is now becoming more pertinent in relation to the relationship between coastal states and the BBNJ agreement that I want to highlight, and that is that where we have resources which lie across the limits of national jurisdiction, in this case the continental shelves, including of course the extended continental shelves beyond 200 miles. We see here that the principle of due regard is utilized, but then a very specific principle, or rather very specific obligation of consultations, including a system of prior notification, shall be maintained with a view to avoiding infringement of such rights and interests, which then requires the prior consent of the coastal state concerned. So it privileges the coastal state in its relationship with, in particular, in this particular context, the International Seabed Authority. Now, there are three categories, I would suggest, of uncertainty in the interface of, in this interface maritime zone, as I call it, or the hydrogeographical space encompassing the continental shelf beyond 200 miles and the high seas area, which now will be subject as part of the ABNJ, as part of areas beyond national jurisdiction, under the 3 minutes. Right, if I've got 3 minutes, I'm going to run through, I'm very sorry. Yes, I'll just highlight these spatial jurisdiction, the definitional issues, and the institutional issues. And in my view, the new challenge is the legal relationship. If I have 3 minutes, what I want to do really is just flick through, and I do apologize to the interpreters, because obviously I'm just going to flick through to the areas where I can specify my points. Yes, so on sedentary species, there are two issues that I really want to highlight. Sedentary species are problematic in their own, and here I would like to highlight the so-called snow crab dispute between the EU and through its licensing of Lithuanian and Latvian fishing vessels, and it's just in its dispute with Norway in the North Star, SIA North Star case, also known as the Norwegian snow crab case. There, the issue went all the way up, and this signifies the importance of these resources. And here we have moved now to talking about, of course, the living resource of the continental shelf. The snow crab were then defined by the Supreme Court, no less, of Norway as being part of their sedentary species in that particular dispute. So this shows that the issue is problematic even between states, but then when it comes to, and this is the area, in fact, I think the ships, the vessels were located when they were arrested in the loophole area there in the Svalbard, which of course comes under the jurisdiction of Norway. So I'll just skip through these. Yes, so the last part is to note, the last point about sedentary species is to note that in fact you've got this possible overlap between sedentary species and marine genetic resources, which of course is the type of resources available to be regulated under the BBNJ agreement. So, and then I wanted to highlight also the institutional issues between the BBNJ agreement and of course the International Seabed Authority, which has authority, as everyone knows, in the deep seabed area in terms of mineral resources in the actual seabed. Right, very quickly then, if I may just go to the applicable principles, and I'll finish off with these principles, if I may, Mr. Moderator. In the case of UNCLOS, we have principles like due regard and the restraint from undue interference. And we can see here that, especially, and also the principles of good faith. And we can see here that these principles have provided us with a set of tools to define the relationship between states, but they are, in my view, insufficiently specific to provide actual standards of behavior, as I mentioned. One example is, of course, the case brought by Mauritius against the United Kingdom in relation to the Chagos archipelago, the UK's attempt to draw what was then the largest marine protected area around the Chagos area. And you can see there, and this is probably going to be my last substantive point, that the tribunal, although insisting that the meaning of due regard was similar to the application of the principle of restraint from undue interference, they declined to find any specific formulation for that. and they preferred, in fact, to approach it on a more or less case-by-case basis. And this, of course, dovetails what has been mentioned also in the keynote by Judge Paik yesterday. So, and here's further information about that. So it just shows that although it's functionally equivalent, there was no actual standard applied. So my observations and conclusions, my observations rather than conclusions, is that several of these sets of issues still need to be clarified. The actual relationship between the geographical space and areas beyond national jurisdiction, the possible overlap between the material scope of the sedentary species and marine genetic resources also needs to be clarified. In particular, we're talking about, for example, benthic organisms. David Leary, in one of my earlier slides, which I skipped over, just to mention, David Leary noted that when we have benthic organisms that exist and they float between the seabed and the immediate water column above the seabed, are they to be considered sedentary species, or will they become marine genetic resources if they go into the high seas column in relation to the BBNJ agreement? And finally, the principles to reconcile coastal state rights and jurisdiction under the UNCLOS against access to MGR, marine genetic resources, for all states, namely good faith, due regard, and unjustifiable interference, for which I'll be very happy to continue the discussion in the question time, are arguably inadequate for ensuring optimal outcomes in and of themselves. And they probably need greater calibration by tribunals. And finally, the institutional framework also needs to be clarified. I'm sorry I've run out of time, Mr. Chair, and thank you everyone for your attention. Thank you very much.
I had affiliated research. This is Macquarie Center for University Sydney, and NH and natural resource innovation and transformation, and he is concurrently the author Watts Research Fellow on the Law of the Sea of the British Institute of International and Comparative Law, and here he leads the International Institute of Watts program and research and training the law of the sea, energy and natural resource law. Dr. Loureides' research focus on the law of the territory, law of the sea, environment, and natural resources, law and species, peaceful settlement of including the UK Art Humanities Research Center Council. And his major topics: management of continental shelf-rich species in the energy transitions, carbon dioxide storage in the transboundary geological formations. Mr. Constantinos. to speak about your talk. Okay.
Thank you very much. Thank you, Mr. Chair, distinguished participants, dear colleagues. It's a great honor and pleasure for me to be here. And I'm grateful to the organizers and particularly Director Park for giving me this opportunity. It's great to see old friends and make new friends. My presentation today focuses on offshore carbon storage in transboundary geological formations. Offshore carbon capture and storage, which is also known as CCS, is a technology of removing carbon dioxide from the burning of fossil fuels and storing it deep below the seabed into suitable geological reservoirs. I will provide some observations on the technology, the perceived benefits, underlying environmental risks, and applicable international law requirements, including under UNCLOS and general international law. I will conclude with some observations on whether and to the extent to which we can use maritime boundary delimitation agreements and related resource sharing agreements to promote the good governance of CO2 storage on transboundary formations. Now, the world is facing a seemingly intractable challenge, human-induced climate change caused by increased levels of CO2 emissions. One of the main sources of such emissions is the burning of fossil fuels such as coal, natural gas, crude oil, for energy production. So according to latest data, fossil fuels account for 82% of primary energy use. Now, very few leaders are genuinely willing to reduce their country's energy needs. Very few leaders are genuinely willing to stop using fossil fuels altogether or even producing fossil fuels. And we've seen many countries recently changing their policies and switching to new fossil fuel production. So one might arguably argue that, there is a very reasonable observation to be made here that we need alternative choices. This is where CCS comes in. It may enable, at least pending other more meaningful solutions, the continued fossil fuel consumption while reducing CO2 emissions. And the United Nations Framework Convention on Climate Change has described CCS as an important option in most of the emission scenarios to reach the 2-degree goal. Indeed, many governments around the world are currently looking to ensure their transition to low carbon economies by implementing CCS. Now, a report by the International Energy Agency concluded that offshore petroleum reservoirs are the most promising option for CO2 storage. That is because the injected CO2 would in essence return to occupy the space it came from. Nevertheless, many of those reservoirs, the suitable locations, are transboundary or of transboundary nature. In other words, the same reservoir may be used on either side of the boundary for geological storage. And that raises important legal implications. The UK continental shelf is an excellent example in that regard. What you see in yellow color on this map is the most promising locations for CO2 storage on the UK continental shelf. Many of those locations are transboundary. Now, this pragmatic reality raises several environmental issues. These include groundwater contamination, anthropogenically induced seismicity, general ecological degradation, and other harms not directly related to marine pollution, such as pressure implications affecting the injectivity of the reservoir, meaning that one state's injection and storage operations may affect the other state's ability to do the same. Overall, if the target CO2 reservoir crosses the maritime boundary, or worse, there is no boundary in place, any uncoordinated action could result in some form of transboundary harm. So there are many questions that we can ask, and I'm not going to attempt to answer all those. It's just to raise those questions for anyone interested. How can we ensure the sound verification of the transboundary geological formations? How will information on storage locations be tracked and disseminated to all parties interested in the shared formation? What are the time frames for CO2 storage? Are we talking of 10 years, 20 years, 100 years, 1,000 years? What are is it realistic to keep monitoring CO2 storage for many years down the road? And who will pay for those ongoing monitoring operations post-injection? Under UNCLOS, the coastal state has exclusive jurisdiction to authorize and regulate the conduct of seabed-related activities, including drilling and construction of energy installations on its continental shelf. That arguably includes carbon sequestration and storage operations, because this is an economic activity related to the economic exploitation of the seabed. At the same time, states are under a general obligation, and this is something that Professor Ong concluded in 1999, so many years ago. States are under this obligation to cooperate with each other over shared hydrocarbon resources. So under customary international law, no state may exploit a common liquid deposit before negotiating the matter with neighboring states in good faith. The duties associated with the general obligation to cooperate over shared resources include both procedural and substantive duties. And you can see those on the slide. For example, the duty to exchange information about the resource, duty to notify on proposed activities, duty to conduct an environmental impact assessment, and others. There is also a general duty under UNCLOS to cooperate with respect to the protection of the environment, and this is a substantive duty. This duty would also be relevant for CCS. However, this is probably an obligation of conduct, not of result. States are under an obligation to cooperate in good faith and regulate shared environmental risks, but there is no positive duty to reach agreements. In other words, failure to reach an agreement will not in itself constitute a breach of the duty to cooperate. Failure to reach an agreement over transboundary CCS will not be a breach of the duty to cooperate under UNCLOS. Now, beyond UNCLOS, it would appear that the only treaty forum that has addressed CO2 storage in shared geological formations of the continental shelf is the protocol to the London Convention on the Regulation of Dumping. The London Protocol was amended in 2006 and 2009 specifically to allow the transboundary transfer of CO2 and its injection into the seabed for long-term storage. Thus, as it stands, under the London Protocol, CO2 injection into the seabed for geological storage is a permissible form of disposal. However, because of the implications, the environmental implications and other implications, as I mentioned, in 2012, so quite recently, the parties to the London Convention and Protocol developed a set of guidelines for CCS operations. The guidelines refer explicitly to UNCLOS, and they underscore that any state wishing to inject CO2 into the seabed for geological storage should seek consent from the other state or any other states with jurisdiction over the same geological formation. The guidelines do not prescribe, however, the form that the consent must take. Is it an international treaty? Is it an informal arrangement between the two governments or between their public or private sector operators? It could be anything. It could be simply an exchange of diplomatic notes. The guidelines do not stipulate the legal ramifications of failing to obtain the consent of the other state. In other words, the guidelines imply that one state should seek consent, but it's not under an obligation to obtain that consent before injecting CO2 into the seabed. The guidelines do not provide guidance on the circumstances in which such consent may be withheld. Now, let us turn to maritime boundary delimitation and other agreements over shared resources. International practice indicates that many states delimiting their maritime boundaries have included the so-called straddling deposit clauses. An early example is the 1965 delimitation agreement between the UK and Norway, which provides, and you can see the relevant provision on your slide, if any single geological petroleum structure or petroleum field extends across the dividing line, the parties shall seek to reach agreement as to the manner in which the structure or field shall be most effectively exploited. Most recently, that is last month, the maritime boundary delimitation between Lebanon and Israel includes provisions on the exploitation of a specific hydrocarbon prospect shown on the map as Ghana prospect. You can see it on the green color right across the delimitation line. The Ghana prospect is believed to straddle the agreed maritime boundary, and the two states and their respective operators, and you can see the relevant provision on the left-hand side of the slide, have assumed an obligation to establish a mutually acceptable regime for exploitation which preserves the rights of the parties and maximizes efficient recovery, operational safety, and environmental protection in accordance with good petroleum practice. The provision refers to the duty to comply with the applicable laws and regulations in the area, but it doesn't specify which are the applicable rules and regulations in the area. Is it the rules and regulations of Lebanon? Is it of Israel? Is it both? To the extent that is both, to what extent are they compatible? In fact, speaking of the Eastern Mediterranean Sea, an area that I'm very familiar with, there is widespread state practice among the states of the Eastern Mediterranean Sea to include clauses on the procedure to be followed where a single geological structure crosses the boundaries between states. And this is the clause, the standard straddling deposit clause that is contained in at least 5 maritime delimitation agreements in this region. This clause provides for the duty to cooperate over shared natural resources, and thus it mirrors the requirement under international law to seek cooperation on the development and sound environmental management of natural resources among coastal states. Such clauses are considered to reflect best practice as required under UNCLOS. There are many agreements across the world, including framework agreements dealing with all future shared natural gas or any other form of natural resources across boundaries, including, again, quite recently, the Australia-Timor-Leste Maritime Boundary Agreement, which establishes a special regime for shared hydrocarbon resources between the two states. Now, the question we face is whether straddling deposit clauses and related hydrocarbon sharing agreements should be read as extending to transboundary CO2 storage and related operations. For instance, and this is a question I would like to pose to everyone, what is the legal position where a transboundary project in a hydrocarbon reservoir moves from joint development, like the production, to a joint CO2 injection and storage? This is the reverse scenario, from pumping out to pumping back in. Some states may view CO2 storage as incidental, simply the continuous form of present oil and gas production activities. In this view, existing straddling deposit clauses should be applicable. Other states would view CO2 storage operations are being totally separate from existing provisions. Presumably, and this is a reasonable argument, the straddling deposit clauses I mentioned earlier were only designed for the exploitation of hydrocarbons for commercial gain by means of extraction, rather than exploitation of the seabed by means of injection and storage. For instance, and you can see the relevant passage of the Australia-Timor-Leste Maritime Boundary Delimitation Treaty, which defines petroleum activities as all activities undertaken to produce petroleum. And that includes drilling, it includes exploration, development, processing, and production. No word about CO2 storage. Now, my conclusion is that this is problematic. We have to start thinking ahead. We have to start thinking about how to prevent future disputes. If we consider the environmental risks associated with uncoordinated carbon storage and possible infringements of sovereign rights under UNCLOS, we would be well advised to prefer a sounder environmental approach to transboundary carbon storage. The use of the shared geological formations should be made conditional on meeting specific requirements. Cooperation between states with jurisdiction over the shared reservoir will be necessary. And in that regard, boundary agreements and related agreements over shared resources can be used to determine those terms of cooperation beforehand, before it's too late. This is also based on a precautionary approach to ensure that such shared use will be environmentally sound and sustainable. With that, I thank you for your attention, and thank you, Mr. Chair, for allowing me. Thank you.
My discussant, the Bjorn Knoy, Professor, University of Ireland, is now time. You have time. You have time, okay?
Thank you, moderator. First of all, congratulations to the speakers of the panel. Excellent presentations, insightful. I think I learned a lot. I shall start making comment to the first speaker, Dr. Rajan, who rightly developed some of the challenges that the CLCS is facing in its work. State that submits a claim to Outer Continental Shelf under Article 76, Paragraph 8 of UNCLOS today could expect its claim to be considered in 25 years or 30 years, as the procedures are now. And this would appear non-satisfactory in many regards. And I believe that Dr. Rajan touched upon how to address this in a fair fashion going forward. A question that arises also in this regard, and which is of great importance, to me at least, and I think for most others also, is how to approach the question in regard to consideration of submissions that are subject to overlapping claims by neighboring coastal states, and to which there is a veto made by the relevant states under Annex 1 of the Rules of Procedure to the CLCS. There have been a number of vetoes lodged to the consideration of submissions by the CLCS, and which has resulted in a deferral of the submission of the consideration of those submissions, notwithstanding the principle of queue. Therefore, the CLCS has simply deferred the consideration of such submissions. And this is unfortunate in many regards, and one wonders whether there is a sound basis for this, given that Article 76, paragraph 10 under UNCLOS provides that nothing under that provision, under that article, can prejudice matters regarding to maritime delimitation with states that have opposite or adjacent coast. And also under Article 9 of Annex 2 to the UNCLOS, it is provided that the actions of the CLCS shall not prejudice matters in regard to maritime delimitation. But can it be seen that making recommendations, which from a legal point of view are not binding, can prejudice matters to maritime delimitation? Are they not more rather seen as a prerequisite to proceed with maritime delimitations? And in this regard, I'd like to mention two things. Under Annex 1 to the Rules of Procedure of the CLCS, Article 2A of the Annex 1, there is an obligation on states to provide information whether or not the disputed area, the area that is subject to a submission is subject to a dispute. And in that regard, it distinguishes three scenarios of disputed areas. One is disputed land territory, second is disputed maritime territory, and thirdly, disputed continental shelf areas. Therefore, there is a distinction made between maritime disputes and continental shelf disputes in Article 2 of Annex 1, although according to the normal jargon, one may use maritime areas as also including maritime areas stricto sensu, but also continental shelf. But if one were to apply the rules of interpretation under the Vienna Convention law of treaties, which I would not say would necessarily be the case, given that these are the rules of procedure of the CLCS, it is startling to note that the provision in which states base their vetoes to the consideration of submissions of third states is Article 5A of Annex 1, which does not follow the three-step approach in Article 2A of Annex 1, but rather a dual approach in which it only differentiates between disputed territory and disputed maritime areas. It does not refer explicitly to disputed continental shelf areas. And I believe this is very important detail in order to proceed further on whether the CLCS should be in a position to consider continental shelf areas that are subject to overlapping claims by third states. Now, proceeding further, knowing that the moderator also would want me to not extend my comments more than necessary, I'd like to touch upon in a joint manner on the presentations of Professor Ong and also Joel Arets. Looking more of what is a shared non-living resource, non-living natural resource. General international law would not provide an non-equivocal definition, and it's also important in this regard to look at state practice. And most importantly, state practice differs significantly, both on substantive and also on procedural grounds. Now, so far concerns procedural grounds, there is a question on whom is there an onus to determine whether or not a hydrocarbon deposit is transboundary. It's a question which appears non-settled. You would find agreements in which that if you have a delimitation, a hydrocarbon deposit which would be situated within X amount of kilometers from the maritime boundary, and it would be seen as being exploitable, there would be a presumption of that shared resource being transboundary. There would be the reverse also. That would be if there is a discovery of a hydrocarbon deposit on one side of the maritime boundary, it would be for the other state to determine, to provide sufficient data, allowing a determination that the hydrocarbon deposit is transboundary. So there's different practice. On which data? We also see that the states approach this very differently. Some require merely refraction or seismic data. Others would require drilling data. So these are outstanding issues which would not appear to be settled. Now, insofar concern substantive matters, there is no overwhelming uniform practice on what is a transboundary deposit. You can even find situations in which it is not a necessary requisite that the geological deposit, no, the hydrocarbon deposit physically straddles the maritime boundary. You can see an instance of this in, for instance, in the 2010 Maritime Delimitation Agreement between Russia and Norway, which is based, I would think, fair to say, on a regional approach that has been used by Norway and Denmark and also Iceland for a number of years, in which that, to the extent that the exploitation of a hydrocarbon deposit on one side of the maritime boundary may impact the possibility for exploiting a deposit on the other side of the boundary, for the purpose of the delimitation agreements in question, the deposit should be seen as transboundary. So that is a very interesting approach in many regards. But I would think this would be something that could be classified as a regional approach. For the purpose of this comment, I have identified three main characteristics insofar concerns whether or not a hydrocarbon deposit is a shared resource. First of all, there is a requirement that on each side of the boundary, one should be able to exploit wholly or partly the resources on the other side of the boundary. An example of which is the 1974 delimitation agreement between Korea and Japan. Secondly, there is a requirement that the exploitation of the amounts of the transboundary deposit on each side of the boundary must allow viable economic exploitation on each side of the maritime boundary, an example of which is the 2012 Unitization Framework Agreement between the US and Mexico. Thirdly, there can also be a requirement to merely being able to recover hydrocarbons from either side of the maritime delimitation agreement, but not necessarily in a manner that would allow sufficient would not allow a viable economic exploitation. An example of this is the 2004 delimitation agreement between New Zealand and Australia. The question arises, what is the situation if the parties are not in agreement, notwithstanding procedural rules that would determine whether or not a deposit is transboundary? And a large number of these delimitation agreements are silent on this issue, completely silent. There are some exceptions, though. One is the identical, three identical maritime delimitation agreements between Denmark/Faroe Islands, Norway, Denmark/Faroe Islands, Iceland, and Iceland/Norway. I was myself head of a delegation in the negotiations of that delimitation agreement, and facing this problem, we managed to agree on a procedure in which an independent expert should be appointed in the event that there is a disagreement on whether or not the criteria determining whether a resource is transboundary are fulfilled. And finally, this leads us to the question also whether or not it is possible to see a trend in state practice with respect to the question that was touched upon, particularly by Professor Jolorardis in his presentation, on whether a unilateral exploitation can be allowed in regard to a joint resource. There are both approaches that appear in the delimitation agreements in the state practice. You can see, for instance, in the agreement from 2012 between the US and Mexico, that in the event that the parties are not in agreement to in the event that parties are unable to agree on a joint exploitation of a transboundary resource, they may proceed without agreement. I will not say, perhaps I should be careful saying unilaterally, because according to the provisions of this agreement, there would be obligations of payments to the other party. So it would not be strictly sensu unilateral, but the consent of the other party need not necessarily be required, subject to conditions in that regard. On the other hand, you have the agreement from 2010, Russia, Norway, and you could also see this approach with some deviations in the 2019 delimitation agreements, not allowing unilateral exploitations of shared resources. But also, and again, the overwhelming state practice is completely silent on this. It's quite unusual that the delimitation agreements have a view on this. Express opinion. Well, it is unusual that these delimitation agreements address this particular question, which also would raise the question that that was raised in the last presentation, whether or not these delimitation agreements may be seen applicable mutatis mutandis to the storage problematic. I would think that I had more or less touched upon the comments that I would want to make on this. Thank you very much for your attention.
Thank you. And now the questions about the speakers. Firstly, Mr. Professor Razan, you will ask him, or what do you want? Just you talked about, okay?
Yeah. I made some comments.
Okay. Mr. Yares, you have.
Thank you. Thank you very much, and Mr. Park, and thank you very much to all presenters for very interesting inputs. Of course, Mr. Park was very kind of mentioning my name at the very beginning, so let me make a couple of comments in my former capacity as the Secretary of the Commission on the Limits of the Continental Shelf on some of these issues, and including on the issues of disputes in the case of land maritime boundaries. I'll try to be short and concise. You know that the Commission is facing a considerable challenge that is mostly due to the legacy of the drafters of the convention 40 years ago. They didn't realize that putting 21 scientists in the same room, it's worse than putting 21 lawyers in the same room. And of course, what scientists wish for, it's always data and data and data. And that, of course, resulted into the adoption of scientific technical guidelines. They want scientific and technical data. And that's presented many countries with these challenges. The amounts of funds spent on the preparation of submissions to the Commission on the Limits of the Confidential Shelf go into billions of dollars. This is a single underestimated and underfinanced United Nations body, which does its work in a very, I would say, unfavorable conditions. And I'm not going to go into details. The conditions of service are, of course, before the meeting of states parties, sufficient information, public domain in the documents of the meeting of states parties and of the Commission. However, of course, the Commission is not only challenged by the workload, it's considerable challenge by the situations when there are issues between states, mostly neighboring states. And I think that the discussant Bjorn has highlighted a couple of them. The problem here is that the Commission is not equipped to deal with these issues. The only tools that the Commission has is the Convention and its rules of procedure. The reason that is not equipped, of course, to interfere into the issues of maritime boundary delimitation and disputes over the land, because this is a group of scientific and technical experts. The task is as simple and it's of technical nature: to review submissions, to look at the application of two formalities, to constraints or statement of understanding, and to issue recommendations on the delineation of the outer limits of the continental shelf, on nothing else than that. Of course, when the Commission was preparing its rules procedure, issue of disputes has arisen, and the disputes regarding land boundaries, sovereignty over land is of course particularly challenging because of course it impacts the maritime spaces. In fact, it's quite unusual in the practice. Normally the body that is adopting its rules of procedure doesn't reach out anywhere else. It just considers its rules and adopts it, and hence of course it applies to this body. Here, because by necessity, some of the elements of the rules of procedure apply to submitting states, the Commission reached out to the meeting of states parties to the Convention on Annex 1 and on Annex 2 confidentiality. And these documents, the rules of procedure, were before the meeting of states parties. So the Annex 1, it's not the result of Commission's creativity, no. The Annex 1 on disputes is a result of a direct input from states. This is in fact reflected in the wish list. Later on, some states realized that after all, it was not such a good idea, but it gives the Commission a greater comfort, and so far the Commission has been faithfully following the Annex 1 in knowing that the moment there is an objection, there is no consent of states to go ahead when there are overlapping claims, and I would not necessarily call them disputes, because sometimes overlapping claims are results of geography. If both states are agreeing on the process to go ahead subject to later delimitation, there is no disputes per se. And in fact, there is an agreement between the submitting states. But if there is no agreement and if one state feels uncomfortable, then of course the Annex 1 facilitates the life of the Commission because it exempts it from dealing with issues between states. States have sufficient tools to address their problems themselves. They don't need to drag the Commission in because the Commission is an expert body. And by definition, the Commission cannot help them because, in fact, whatever they do is without prejudice to delimitation. So this is something of these dynamics that the Commission is facing. In fact, also in the practice of states and the Commission, it's interesting to know that some states which on one hand are very unhappy with their neighbors blocking their consideration of their submission are using the same tool in order to block. And there are some recent examples, I'm not going to mention them, but if you were to look at the most recent developments, you see that one state has been, in theory, stopped. The consideration has been blocked by a neighbor, but then the same state uses the same tool in respect to the submission of another neighbor. So as we say, this is a widely used technique. Of course, states are sometimes reconsidering, and that was the case of Somalia, Kenya, which has the very bumpy road, but still ultimately the consideration of the Kenyan submission could go ahead. So yeah, the situation is not simple for the Commission. Of course, how the Commission is going to deal with the workload is a challenge, as Dr. Rajan mentioned. There are considerable challenges, not only in terms of working methods of the Commission, but also in the complexity of the submissions and the interaction between submitting states and the subcommissions. Because the moment when the submitting state is before the subcommission, it wants all the subcommission's attention. And of course, if there is a perception that the subcommission's potential recommendations do not entirely meet the expectation of the submitting state, of course the states want more time to come back to provide additional data, etc. So the issue is not only on the side of the Commission. The states are equally guilty, if you want, into this lengthy examination of the submission, because many of them, should they feel that they may sway the view of the subcommission by providing additional information data, they normally choose to do so. So yeah, it's a very complex, and I think I should stop here because I can go on and on for hours. Thank you.
Thank you very much, Mr. Yares. And who else? You first, the lady.
Thank you so much, and wonderful panel, wonderful presentations. I can't help but bounce back. I'm on Team Bjorn on this one. I think the convention had a firewall. It was aware that it was 21 scientists, and that's why. Look at the science. Does State A, does its science hold that its continental shelf extends? Look at State B, does it extend? And then throw it back to them, because blocking is just not going to help anyone unravel these. I mean, I find that very curious. I just found that the firewall was there, but I understand, I find it so interesting that it was states that didn't have faith in that firewall. My question in its ignorance, I'm sorry, to the last panelist, what happens, you know, it's already the problem was, have they thought of it? Is it included? Will the issue arise? I mean, there are some substantial possible risks that you listed. What if one of the states says it's not a good idea? Does that come up in discussing? What if the same province where it might be great to inject, and one of the two parties says, I don't think it's a good idea? Or do you think there's a consensus building that is always going to be a good idea? Do the benefits outweigh the risks?
Well, I'm not a scientist, to be honest. I would say the benefits are, you know, whether there are more benefits than risks. In international law, we say that you should always adopt a precautionary approach. And even if the evidence of environmental harm are not concrete, that should not prevent meaningful action to prevent those risks. And I think UNCLOS is based on that understanding that you should prevent the harm from occurring, not simply seek to provide redress from a harm occurred, but you should prevent it in the first instance. That's why I'm arguing that these things are always best to regulate beforehand, because there are two main objectives when it comes to carbon storage. Choose the right locations and then prevent operations that would turn those right locations into bad locations. And to avoid the second, you have to have cooperation, coordinated action. Now, whether you have to obtain consent before injecting, this is a question I raised. In international law, it seems that there is an expectation to negotiate in good faith. There is an expectation to exchange information, all the other procedural obligations, but there is no legal obligation to conclude an agreement. That is subject to sovereign prerogative of states. So thank you for your question. I'm sorry I wasn't able to answer.
Okay, and next, you, Mr. Wang. No, you first.
Yeah, first of all, I would like to congratulate the three excellent presentations and also the brilliant opinions from the discussant. My question is to David. Yes, when you're talking about the snow crab case, it reminds me the incident between Canada and Spain in 1995. That's about the halibut incident. And actually that issue pushed the formation of the 1995 UNFSA Fish Stocks Agreement. So I'm wondering if there is more, state practices such as the snow crab cases, and there will be more dispute happened, just like the incident between Canada and Spain in 1995. Do you think this will be another motivation to push more state jurisdiction into the high seas or seabed area? Thank you.
Thank you, Mr. Chair. And thank you, Dustin, Professor Wang, for that excellent question. Yes, that enables me to highlight the issue of sedentary species within overlapping continental shelves or within continental shelves which adjoin between coastal states. So the other part of the problem, of course, is the overlap between sedentary species at the outer edge of a continental shelf beyond 200 miles and, of course, the area beyond national jurisdiction. But Justin's question relates to the issue between coastal states. And yes, I believe that we will see more disputes between states, especially between deep water fishing states and coastal states, as coastal states begin to realize the potential of species like crab and lobster. So two examples actually from already from history. In the, I believe, going back even to the 1960s, there was already a dispute between France, between French fishermen fishing for lobster fishermen, and Brazil. And that was the subject, obviously. I think it was ultimately settled by some form of modus operandi rather than Suzanne is nodding, so she may know more about it. And that was one issue. And indeed, in earlier editions of the famous textbook by David Harris, Cases and Materials of International Law, he cites a statement by the UK Foreign Office, UK Foreign and Commonwealth Office in Parliament, in the UK Parliament, where the UK government, ostensibly in order to protect lobster fishermen from the United Kingdom fishing in the coastal zones of other states, the UK government actually made an official statement to the effect that lobsters were to be considered to be not sedentary species because apparently lobsters swim, whereas crabs, and this was of course then to protect British crab fishing interests nearer the coastline, their own coastline, whereas crabs, in line with the Norwegian, present Norwegian case, are to be considered sedentary species. So these kind of, in my view, artificial distinctions are being made, have already been made in the past, and I think they will resurface in the future. Thank you.
Okay, next, you speak.
Okay. Thank you, Chairperson. I'm sorry for eating into the break time, but I have. I'd like to extend my thanks to wonderful presentations, and I have a question. I'd like to, comment a question put to Professor Ong, and thank you. You covered much ground in your presentation in a very expert manner. Well, but I have a small comment to make concerning your characterization of provisional, the draft Article 4 of the BBNJ. And I think in your presentation you used the expression there was rather anachronistic approach, right? And your point of criticism was that that provision was privileging, according to your expression, or prioritizing the UNCLOS over the BBNJ agreement. Well, in that respect, I have two comments. First of all, if you look at, I think, provision Article 311 was mentioned by Professor Kunoy yesterday, and he mentioned Article paragraph 3. But if you look at paragraph 2, then one can say that, well, that's, I can't go into all the detail, but that provision is based on the idea of UNCLOS as lex superior in some context, right? So that's my first comment. And the second one is that, well, if you think about the relationship between BBNJ and UNCLOS, well, maybe I'm recycling the trichotomy I used yesterday, but it's not just a conflict, right? But at the same time, BBNJ can provide some changed interpretation, or you can fill up the gaps, right? So maybe one can approach this question in a more flexible and dynamic manner. Yeah, that's my comment. Thank you.
Comment? Comment? Okay. And Professor Ora, you have.
Thank you. I also apologize for going into the break period, but fantastic presentations. Very, I would say, very critical thinking and things I actually did not think about. So I congratulate everyone, including the commentator. My question actually was came to mind after Suzanne's question, and it's to Professor Eularides. I'm probably mispronouncing, but Constantin. In these agreements, and the question you raised about whether there's disagreement between one's is an agreement, one says no, there may be a marine environmental harm, but we also know that the Law of the Sea Convention under Part 12 provides for what we would call today environmental impact assessments, particularly Article 206. Is there, in those agreements, is there any potential for that? And is that an obligation that should be just read into those agreements? And do we see that happening? So I'll stop there.
Thank you. Excellent question. Yes, I think the duty to carry out an environmental impact assessment and equally the duty to communicate that assessment to the other affected parties is crucial in that regard. It should be embedded in the regulatory design. And what I would also argue, with a caveat from what Professor Kunoi said about how to qualify transboundary resources, because all of these are triggered if there is a transboundary resource. But who decides if there is a transboundary resource? The states themselves. So if you have a dispute about the shared nature of the resource, then that comes first. You have to resolve that first, and then what duties apply if this is indeed a shared resource. What I would argue is that if it's a shared resource, then there will be a duty to carry out a joint environmental impact assessment. So one state could simply invite the other state to join the impact assessment, the carrying out of the impact assessment. And if the other state declines, then the injecting state had every ground to say, I made my part of international law, I met my obligation, so I can now proceed. So maybe that's a very good solution to take it forward in case we have a dispute.
Okay, just 1 minute, so you speak.
Thank you, Moderator. Just a short final comment, which would mainly touch upon some of the comments that were raised by distinguished Director of Doualos earlier. In my initial commentary, I highlighted that there are differences in Rule 2A of Annex 1 to the Rules of Procedure, by contrast to Rule 5A of the Rules of Procedure, of the Annex 1 to the Rules of Procedure. And the basis for lodging vetoes is 5A. So if one would think that it would be feasible to make recommendations without prejudicing matters relating to maritime delimitation, there may be an avenue in this particular difference. And in this regard, I'll also briefly note one element, which I would think would touch upon some analytical or academic aspects in this regard. The approach, which is today, is that any state basically, or subject to one exception, if any coastal state that has a coast that is opposite or adjacent to the submitting coastal states can block the consideration of the submission of the relevant state, appears to be based on the understanding that no state may make an outer continental shelf claim that may overlap with the potential entitlement of the other states. In this regard, I think it's very important to note that Article 77, Paragraph 2 of UNCLOS, embedding the inherent rights, is almost duplicated from Article 2, Paragraph 2 of the Geneva Convention, but with one particular difference, is that Article 2, Paragraph 2 of the Geneva Convention on the continental shelf provides that no state may make a claim to the continental shelf of the other state, but this is omitted from Article 72, Paragraph 2 of UNCLOS, and I think it's a very important detail. Thank you.
Okay, then we finish these first sessions of the managing of that these 3 speakers, and one Jeroen Kunoi is a very excellent discussant, and 4 others, 5 questions and comment on all of things and so much. And Mr. David Ong and Mr. Yaras, Yellow-Riders, and I do thank you very much. And we have the just other things, the 7 minutes or others, yeah, we continue this after the morning sessions. Okay, thank you very much. Thank you very much. Thank you.
Thank you. Now we have break, short break. So please join us again at 11:20 a.m. 20 past 11. Okay. Thank you. 수잔 나론도 주세요. Hey, Dr. Susan. Dr. Susan. Here you are. Oh, it's a long trip here.
Yeah, so I guess we were, yeah, actually I was just asking Mr. Young about you. So was it going, everything is fine? So almost 5 years? Yeah, more than 5 years. So it was July of 2017.
Anyway, congratulations. You
thank
have
you.
a really good,
No, it's
good job.
Oh yeah, but I really had a problem in coming here. So my passport was stuck there in the embassy because they were on holidays and there was some
process.
Actually, there was some function going on in a different city, and everyone was engaged there. And we have a very small embassy there. So anyways, so really good to see you. So I'm in touch with some of our colleagues. So I keep traveling to US. So I met Amanda and then Emily, and I was, Mr. We have another colleague from Vietnam. He was doing PhD in Utrecht. So Emily already lives in Amsterdam. So I met him a couple of times there. So really good to see you. So thank you very much.
Have a nice day. 안녕하세요. 11시 12시. 네, 참석자 여러분, 다음 세션 시작하겠습니다. 착석 부탁드립니다. Okay, participant at the lobby, please take a seat. 연구진 여러분께서 좀 외부에 계신 참석자분들 안으로 안내 부탁드립니다. 아니 저기 책상 같은 거나 뭐 앞에다가 두고 들어가실 때 그러니까 이거 어디로 문을 들어가야 되지? 아 이쪽으로 가야 되나? 이따가 자시죠. Miss Imali? Miss Imali? Mr. Chrissy? 저 연구진 여러분, 밖에 계신 참석자분들 안으로 좀 안내 부탁드립니다. Miss Imali and Mr. Kirsi. So, okay. Now we start the special session, Young Scholars Agora, which is very first forum we ever have organized. So the moderator of this session is Dr. Kim Do-young, the former Deputy Registrar of ITLS. Now I will turn this session over to him.
Yes, good morning. Nice to see you again. Let me begin with expressing my deep appreciation to the Korea Maritime Institute and its staff for organizing this wonderful conference and giving me an opportunity to be part of it. I am Do-young Kim, assigned to act moderator of this last session, a very special session. This session, Young Scholars Agora, is designed to give young bright scholars selected through a competitive process an opportunity for them to make a presentation on various maritime topics. As the subtitle of this session indicates, the topics they will address concern challenges to the UNCLOS and the capacity building of young generation. I expect that we'll hear interesting perspectives of young scholars from different regions of the world. We have 6 speakers. However, the time allocated to this introductory session is 30 minutes, which is not enough for full presentations. Because of this time constraint, the main session will be held in the afternoon after lunch. The main session will start at 1:30 p.m. after lunch and end at 3 p.m. I would highly appreciate your participation in the main session. I expect to see all of you in the afternoon. Now we are going to begin this session. I will give each speaker, because of this time constraint, only 3 to 4 minutes. I appeal them to be very concise in introducing their presentations, just making a gist of it. I'm very sorry for that. In the main session this afternoon, I promised more time will be given to each speaker. Now let's start this introductory session. Our first speaker is Ms. Imali Manikarajige from Sri Lanka. She is a lecturer at the Department of Fisheries and Marine Sciences of Ocean University of Sri Lanka. She earned her BSc degree in Fisheries and Marine Sciences from Luhana University and MSc degree from World Maritime University of Sweden. She has more than 10 years of professional experience as an educator and a researcher in the field of marine and maritime affairs. Her topic is marine and maritime education for sustainable blue growth, our challenges in the developing world, and how UNCLOS can set the ground for opportunities. Ms. Manikara Chige, you have the floor. Please be brief. Yeah.
Thank you very much, Chair. Very good morning, ladies and gentlemen. My name is Imali Manikarachi, and I'm a lecturer at Ocean University of Sri Lanka. Today, my presentation is going to be on the topic of marine and maritime education for sustainable blue growth, our challenges in the developing world, and how UNCLOS can set the grounds for opportunities. We all know that education provides ventures for personal and professional development in terms of shaping an individual's attitudes, character, ideas, and skills. One can make use of acquired knowledge and practices through education to create opportunities and change the world in a positive way. In my presentation, I'm going to talk about how marine and maritime education would be important for the development of the concept of blue growth or blue economy, especially in the case of developing countries, and how UNCLOS can provide opportunities of capacity building. There I'm going to address mainly two articles from UNCLOS, which is article number article number 13, marine scientific research, and also transfer of marine technology. Because these two areas are very much relevant to the mandates of universities and maritime education centers. And I'm going to talk about what are the difficulties prevailing in maritime and ocean universities in the developing countries, and how those challenges could be addressed by implementing UNCLOS, and also addressing the challenges of UNCLOS for dissemination of knowledge. Thank you.
Okay, thank you. Our next speaker. Our next speaker is Ms. Maria Penosa. She is from the Philippines. She recently joined the International Maritime Organization as a depository and legal office under its Legal and External Affairs Division. Previously, she was a research associate with the Ocean Law and the Policy team at the National University of Singapore Center for International Law and the legal office for the University of Philippines Institute for Maritime Affairs and the Law of the Sea. She'll talk about towards the development of a legal framework for autonomous ships, developments at the International Maritime Organization. Ms. Penosa, you have the floor. Yeah.
Thank you, Chair. Good morning to everyone, and thank you very much to KMI for this opportunity, and to Director Park and the wonderful staff of KMI for bringing me back to Korea for this conference. I recently joined the IMO, and as such, my interest in the topic of autonomous ships has greatly evolved from having observed it from a law of the sea perspective, looking at the impacts of the new regime for autonomous ships on flag state jurisdiction as we know it under the law of the sea, to now a more, you might say, procedural, if not a regulatory perspective, being part of the organization where the discussion is ongoing as to this topic. So I would just briefly, for this introductory session, distinguish between what the IMO is doing and the greater discussion surrounding autonomous ships or vessels or devices that may not necessarily be covered under the concept of maritime autonomous surface ships. That is the scope of the narrower discussion at the IMO. Of course, the paramount question when talking about autonomous ships is whether they conform to our general understanding of what is a vessel or ship under the law of the sea, which is not actually elaborated on by the UNCLOS. But it seems that in the last few years that the discussion has been going on, the narrative or the drift of the discussion has been moving away from that towards really a preparation for the advent of these new technologies and how it will interact, they will interact with the existing legal instruments. And so at the IMO, the treaties for maritime safety, for facilitation, and for liability and compensation are the ones that we are focusing on. And we are seeking to see, depending on the level of autonomy involved, to what extent these instruments will have to be adapted or modified. And I will elaborate on the updates later on. Thank you very much.
Thank you, Mr. Penosa. Our third speaker is Mr. Baker Matobu. he is not with us now. Unfortunately, he was not able to take his flight from Germany due to the bad weather. But he will join us via Zoom this afternoon in the main session. I'll introduce him this afternoon. Okay, our next speaker is Ms. Raquel Soto Sanchez. She is from Mexico. She is a PhD scholar of the National Council of Science and Technology of Mexico. She is a research fellow at the University of C, a former research scholar of the National Council of Science and Technology of Mexico on the protection and the preservation of the marine environment under the visionary umbrella of the common heritage of mankind with applications of science diplomacy. Her topic is the protection and the preservation of the marine environment following the common heritage of mankind principle. The general principle of international law to protect and preserve the environment comprehended by the Earth's indigenous people's knowledge. I think her presentation would be very interesting. Yeah, Ms. Soto Sanchez, you have the floor. Yeah.
Thank you very much. It is a privilege as an alumni of the Yeiso Academy on the Law of the Sea to be here this time with such a great panel and to listen to all of you in your prior presentation. Coming at last in the program is not an easy task. It's quite challenging for me now because at some point the prior speakers have already touched some issues on within my presentation that I will try to address. The research that I will be presenting is quite visionary. It's a remodel of the CHM principle that argues for the inclusion of indigenous people knowledge, on the one hand, for truly inclusion and overcoming the decolonization of knowledge, but also to fully integrate all the knowledge that we need as humankind to draft and regulations aiming the truly protection and preservation of the marine environment. I'm quite eager on my presentation because my colleague will be discussing as well the CHM principle, but from a different perspective. So I'm quite happy to be here to sharing the table. Thank you very much.
Yeah, okay. Thank you, Ms. Soto Sanchez. Okay. Now I invite Dr. Wasim Karas to the floor. He is from Pakistan. He has been Additional Advocate General Punjab. Currently, he is Advocate Supreme Court of Pakistan. He has authored 10 books, a lot, yeah, and 55 research articles, which have been published in leading law journals in Europe and the United States of America. His topic is protecting the common heritage of mankind beyond national jurisdiction. Mr. Karas, you have the floor. Yeah,
thank you very much. I'm really grateful to the Korean Maritime Institute for inviting me here in this program. So I'm really grateful to the organizers. My name is Wasim Qureshi. I'm a lawyer by profession, and currently I'm enrolled as Advocate Supreme Court of Pakistan. And I'm also a visiting professor in the National Defense University of Pakistan. And I've done my doctorate in international law from Emory University Law School in US. And I have been writing on various topics of international law, including law of the sea. Basically, my presentation today is extension of my article, which was published in University of Arizona Journal of International and Comparative Law on this issue of on principle of common heritage of mankind. Basically, my paper explained the key elements of the CHM principle alongside the concept of equity, which is currently being raised alongside with the CHM principle. Moreover, my paper also explained the key rubrics of the UNCLOS, which are considered as the basis of the CHM principle. The International Seabed Authority has been assigned a specific role under UNCLOS for implementing this principle. The votes and the rules and responsibilities of ISA and the challenges faced by it in relation to the implementation of this principle have been elaborated in that paper. And I've also discussed the controversies raised by the CHN principle and in relation to an explanation of the key elements and the functions of this particular principle. So I'm really keen to discuss this in my presentation later in the afternoon. And once again, I'm really grateful to the organizer for inviting me here. Thank you very much. Thank
you. Thank you, Dr. Qureshi. Our last speaker is Dr. Hoon Jo. He is from Korea. He has just completed his PhD at the University of Glasgow, UK, Glasgow School of Law in the UK. The title of his PhD is Judges Make UNCLOS, Part 15. His research interests include international adjudication, judicial development of international law, and especially the dispute settlement mechanism under UNCLOS. He has recently published 2 articles on this subject in Korea and has begun to present his research at the conference, including the latest Asian Society of International Law Junior Scholars Workshop. His topic today is Challenges to UNCLOS Part 15, Answers from the Tribunals. Dr. Jo, you have the floor.
Yeah, thank you, Chair, for your kind introduction. And good morning, everyone. My name is Hoon Jo, and I'm a PhD graduate from the University of Glasgow in Scotland. And first of all, I am greatly honored to have an opportunity to present my topic today and also to be here in this Agora session with my great colleagues. And as kindly introduced by the chair, my research interests are in the role of international judicial bodies in the development of international law, and most of all, the dispute settlement regime under UNCLOS. And based on these, my research interest, my doctoral thesis argues that the tribunal seized of jurisdiction under rules of Part 15 have generated the lawmaking effect on the procedural law of this convention throughout the last 25 years of judicial practices. And the topic that I'm going to present today is also in line with the overall stance of my thesis. And the title of my presentation is Challenges to UNCLOS Part 15 and the Answers from the Tribunals. As you can easily recognize in this title, this research focuses on what challenges UNCLOS Part 15 encounters and how the tribunals have resolved and answered to those issues. And more specifically in this presentation, I'll present the challenges that the Part 15 system has faced in the past, the challenges it faces today, and the challenges that it will face in the near future. So once again, thank you for listening, and I will look forward to meeting you and discussing this topic with you in the afternoon. Thank you very much.
Thank you, Dr. Jo. We have spent only 20 minutes. We have allowed 30 minutes. But anyway, we are going to have the main session this afternoon. And then in the main session, we'll have the time for questions and answers. And then I hope to see all of you in this afternoon. Thank you.
Thank you. Next is wrap-up session for the conference by Dr. Kim Sung-jin, the former Minister of Oceans and Fisheries. 아니, 어디 서서 하실 것 같아요.
Good morning, everybody. Now we are approaching our final wrap-up sessions. First of all, I'd like to extend my sincere gratitude to all presenters and discussants and moderators. Above all, I'd like to thank for all participants. This year, we hold the 10th Global Ocean Regime Conference. Already 10 years have passed since we established this conference in 2012. Today, I would like to wrap up this final session. First of all, I would like to retrospect past 10 years. And secondly, I would like to summarize briefly the main outcomes from today's conference. And finally, I would like to introduce our future way to go for this Global Ocean Regime Conference. Please let me utilize the excellent interpreters instead of my broken English. So I'd like to speak in Korea for effective understanding of this wrap-up sessions. 지금부터 10년 전인 2012년에
Yes, so I recall that it was 10 years from now in 2012 when it marked the 30th anniversary of the adoption of the United Nations Convention on the Law of the Sea. And I do recall that back then we had Professor Park Yong-an, or Yong-an Park, and we were joined by many maritime law policy experts of Korea. We came together to talk about this very important subject matter, the sea that covers 70% of the Earth's surface, and we wanted to go into what we can do and what we must do going forward. Especially, the seas is our common heritage of humanity, and it also has to do with and it's also the last frontier in terms of it being able to offer the solutions for humanity's key four challenges of food, environment, resource, and space. Therefore, for the sustainable use of the maritime space, and as to what we can do, was the key topic back then at inaugural conference. And as a result, we've had active discussions and dialogue through this conference. So that was the reason behind the advent of this conference. And based on some active discussions, we thought that this conference should encompass not only maritime law or the law of the sea, but also various other maritime affairs. So that's why we decided to name the conference as the Global Ocean Regime Conference. And when this conference was first held in 2013, we weren't exactly sure how many more times we would be able to hold this conference. So we were a bit concerned as to the sustainability of this conference, but it's been now more than 10 years. There is a Korean proverb that says that even the mountains and rivers change every 10 years. But for the past 10 years, we've remained steadfast, and in order to achieve the original goal set, we've been continuing on to host this conference on an annual basis. And the reason why this was possible, the reason why we were able to continue these efforts was due to all of those here today and all of the many experts and scholars for their active cooperation, support, and affection in the conference. And of course, I have to note the Ministry of Oceans and Fisheries and Korea Maritime Institute, of where they've actively provided their cooperation and collaboration. And of course, these institutions and all of these individuals worked behind the scenes to make this possible. So thank you very much for all of your devotion in this conference. Over the past 9 years, the Global Ocean Regime Conference has held various sessions on an array of topics, including legal scientific issues on the continental shelf, East China Sea issues, climate change and maritime law issues, Asian maritime issues, South China Sea arbitration issues, East Asian maritime order challenges, and plans for maritime cooperation in waters in overlapping jurisdictions. And it was basically it included maritime governance, institutional organizations, oceanography, technological innovation, and of course the law of the sea. So it encompassed more than 9 topics. And I know that there were some areas for improvement, but I think that we've also seen some great achievements and progress. And we can say that by dealing with the important global maritime issues, there have been a lot of contributions to academic development and problem solving. But above all, what was most important was that we had this opportunity to have hundreds of maritime law experts gather in one place to present and discuss face-to-face on what we can do going forward, in addition to build friendship and to get acquainted. And I think that this in itself has really contributed to bringing about a peaceful global maritime order around the world. And the opening ceremony, and as was mentioned by many of the experts, this conference is to commemorate the 40th anniversary of UNCLOS. And we can say that we've structured this conference so that it's more future-oriented. So, we, as mentioned, we've engaged in this conference to, of course, understand the progress and achievements, but this was not all. It was about understanding the future threats that can actually bring risk to the international maritime order of what seems to be quite peaceful right now. So that's why we've actually put in place 4 sessions to go into the unsettled issues. In the case of session 1, it was on exercising jurisdiction in the area of overlapping maritime claims. So, in the first session, we've particularly looked into the obligation of self-restraint in the undelimited maritime areas, exercising coastal state jurisdiction for the repression of piracy under UNCLOS, and the MSR in undelimited maritime areas. So we've actually engaged in some active discussion on that. And the second session had to do with military activities in the EEZ. This issue is one of the most sharply contested topics between advanced maritime countries and developing countries in the process of the 3rd Conference of the Law of the Sea. However, UNCLOS was adopted as a package, and in the process, foreign military activities within the exclusive economic zone of coastal states was not clearly described in the provisions of the convention, and as a result, we've been seeing many conflicts arise amongst countries.
And this particular matter is one of the most sharply contended issue between the US and China in terms of law of the sea. And with the most modern scientific and technological development, including UMVs and drones, this issue has been further highlighted. And in relation to these matters, in session 2, we analyzed the jurisprudence of international courts of law, and we also addressed the further highlighted and higher tensions over the Taiwanese Strait, as well as military activities in relation to fisheries. In session 3, we addressed the issue of rising sea levels from the law of the sea perspective, as this matter is severely impacting coastal states, as well as low-lying small island states' survival. Because of global warming, sea level rise is taking place and bringing to fore the matter of adjusting the baseline, as well as many other important law of the sea issues. And in this session, we've addressed legal issues over the matter and also very in-depth discussions and presentations over possible solutions. And just this morning, we had session 4 where we addressed the topic of management of ocean resources and continental shelf. First, we looked at the challenges of CLCS that is in charge of reviewing submissions regarding the extension of continental shelves. And so we reviewed the current situation of the CLCS, remaining tasks, as well as unresolved legal issues over the continental shelf resource exploitation, as well as CO2 storage. Yesterday and today, we also had some in-depth discussions about unresolved issues of UNCLOS. We know that 2 days of conference is not enough to resolve all these tasks. Nevertheless, the conference did present a platform for in-depth presentations and open discussions from various perspectives in writing and spoken words, which will be further disseminated to others. And in the end, by doing so, we believe that this is how we can contribute to resolving some of the unresolved challenges at hand. And in particular, our discussions this year marked the 10th anniversary, and this is all the more significant because of the Young Scholars Agora we just had. This Agora has been prepared to offer an opportunity for young scholars to present their research. With young scholars participating and presenting in this conference and exchanging with global experts, they will be able to further enhance their capacities and expand the breadth of their exchange. In the interest of time, this morning, we only heard a short introduction to their research, but this afternoon we will have the main session, and I'd like to ask you all to participate and encourage our young scholars. Ladies and gentlemen, based on the experience and achievements of the past decade, we are ready to prepare for a new decade going forward. Our ultimate goal would be to contribute what we can to building a peaceful international maritime order. And to this end, the Global Ocean Regime Conference will move forward with the following direction. First, we will expand the opportunity for international maritime experts to engage in exchanges and cooperation. So during the duration of the conference, we will look for ways to allow for experts to engage in closer exchanges and look for ways to continue their cooperation even after the conference. And second, as for the key unresolved tasks of the Law of the Sea Convention that we were not able to address this year will continue to be addressed, and we will continue to look for reasonable solutions. And to this end, we will look for ways to link this conference with research projects and small-scale workshops. Third, we will provide support so that more young scholars can participate in the conference and grow into true experts of the law of the sea. And to this end, we will look for ways to link the GORC with other programs such as the Yeosu Academy of Law of the Sea, which is currently operated by the Ministry of Oceans and Fisheries and the KMI.
Now, I would like to declare this 10th Global Ocean Regime Conference is closing. But before I declare, I'd like thanks for all participants. And last but not least, the dedicated efforts by all KMI staffs, including 2 excellent interpreters, for the more effective and reasonable conference for 2 days. And I wish everybody enjoy today's lunch, and after lunch you will have a chance to taking around Seoul city. Enjoy your remaining stay in Seoul and see you again as soon as possible, any place, anytime. Thank you so much.
Thank you. So now we will have the lunch from now on. And before that, I have some announcement to make. The lunch will be served at the hall just next door here from behind the wall at 12 o'clock. So, and then today we prepare